बात नहीं हो पा रही, माय लॉर्ड में पास ऑर्डर्स ऑन मेरिट सर, उनसे बात नहीं हो पा रही है।
चलिए, एक से रुक जाइएगा। हाँ, उसको बुलाइए, अमित को बुलाइए। अमित लिख रहा था ना वो, तेईस, अमित को बुलाइए, जल्दी से भेजिए, लाइक दीजिएगा, फाइल दीजिएगा। और भी कुछ जजमेंट देने हो तो बता दीजिए, सब एक ही बार में लिखा देंगे।
नो माइंड।
ठीक। पॉजिटिव करना है। 5 छोड़ा था इनका, 23 नंबर। फॉलोइंग रिलीफ लिखा था ना, उसके आगे लिखिएगा। Petitioner's contention is that petitioner are entitled to continue their education as they are students of respectively class 10th, 9th and 8th.
नो सर, 9th, 11th, 10th and 9th.
11th, 10th and 9th in the respondent number 5 school. Full stop. It is submitted that neither TC is being issued nor instructions are being imparted to the petitioners. Next para. On perusal of the writ petition, it is evident that respondent school has issued a demand towards payment of fees in the name of Shri Govardhan Tamrakar, who happens to be father of respondent or petitioner number 2, Dena Tamrakar, towards fees for the year from the years 2019-20 when she was in 6th class, and then for the year 2020-21 when she was in 7th class, then for the year 21-22 when she was in 8th class, and 22-23 when she was in 9th class. Similarly, demand has been raised for payment of fees of Akshay Tamrakar, petitioner number 3, for, for the years 2018-19, 19-20, 20-21, 21-22, 22-23, full stop. These demands are respectively for a sum of rupees 86,345 and 1,04,750, full stop. Petitioner's contention is that their education is crucial and school cannot withhold their instructions only on account of non-payment of fees, full stop. Reliance is placed on the judgment of the High Court of Delhi at New Delhi, decided on 17 January 2023 in WP within bracket C bracket close 584/2023 with CM applications 2281/2023, 2282/2023 in the matter of Master Prabhanoor Singh Virdi versus the Indian School and another, wherein the Honorable Judge of Delhi High Court in para 18 has observed that in para 17 has observed that education has been held to be essentially a charitable object, a kind of service to the community. Full stop. Supreme Court in case of TMA Pi Foundation versus State of Karnataka 2002 SCC Online SC 1036 has dealt with Article 19(1)(g) in the following terms. ये पैरा 17 कोट कर दीजिएगा, full stop. Thus, therefore, thereafter in para 18 it is held, referring to Article 21A of the Constitution, which provides for right to education, that wherein the state has been ordained to provide free and compulsory education to all children of the age of 6 to 14 years. Full stop. Then, placing reliance on the judgment of Supreme Court in case of Bandhua Mukti Morcha versus Union of India and others, within bracket 1984 bracket close 3 SCC 161, it is held that it is the fundamental right of everyone in this country, assured under the interpretation given to Article 21 by this court in Francis Mullin MULLIN case, and thus held that a child's future cannot be allowed to be spoiled and blemished by barring him / her from taking examination, especially at such a crucial juncture. Full stop. Next paragraph. I have gone through the judgment, and after hearing arguments of Shri Mannan Agrawal, I am of the opinion that Article 21 of the Constitution deals with right to educate. 21A, right to education. It reads that the state shall provide free and compulsory education to all children of the age of 6 to 14 years. Full stop. Admittedly, petitioner number 1 and 2, being aged 16 and 15 years, will not fall under Article 21A, and therefore the judgment of Delhi High Court, which has not taken into consideration this aspect while dealing with the facts of the case, and has observed that in the context, and observed in para 20 that in the context of Indian society, class 10th and class 12th board examinations are vitally important and critical, having decisive repercussions and bearing on the future of a student, has failed to take into consideration that a child studying in class 10th or 12th as per the CBSE guidelines will normally not fall within the purview of Article 21A, as for class 10th the age will be around 15 years and for class 12th age will be around 17 years. Full stop. Therefore, this judgment may though be of academic interest but has no application to the facts of the present case. Next. Besides this, it is also important to point out that even if facet of Article 21A to the Constitution of India is applied, a student has a right to education. He has not having any right, he or she is not having any right to have education in an institution of their choice. Full stop. They could have sought admission in a government school or in a public school under the quota meant for students covered under Right to Education Act. Full stop. Next para. It is not the case of the petitioner that they had taken admission in a public school under the Right to Education Act provision and the quota meant for such students, and therefore they are not liable to pay school fees. Full stop. Next para. Though Delhi High Court has mentioned in para 17 and has referred to TMA Pi Foundation judgment that education has been held to be essentially a charitable object, but it is not discussed that if education is to be run as a charitable activity, then where from fees and maintenance of fees nahi, salary to the teachers and staff and maintenance of infrastructure is to be carried out. Full stop. Is state providing for the same in the public schools also? And what is the obligation of public school in regard to payment of fees? Full stop. In fact, annexure P2 reveals P2 nahi hai, excellent. P1 reveals that fees is pending for over 4 years. School has been too charitable to allow the petitioners to continue their education. Next paragraph. When this court asked Shri Manan Agrawal to pay the fees so that appropriate instructions may be issued to the school either to continue the petitioners to seek instructions or to grant them TC as per the choice of the students. Shri Manan Agrawal on instruction submits that he is not able to contact his clients and therefore asked this court to decide petition on merits. Next paragraph. On merits, petitioners without paying fees cannot be shown any charity, and that charity can at best be shown by the counsel if he is so concerned with the interest of his clients, and he may pay the fees by showing a goodwill gesture towards his client. But by no stretch of imagination, a private school can be directed to continue giving instructions to the petitioners without payment of school fees. Full stop. There is no allegation of exorbitant or there is no allegation of demand of exorbitant or undue charges. Therefore, if this petition is to be allowed hypothetically, keeping that humanitarian angle in mind, then that will set a wrong precedence for those students or those parents who are paying such fees in the schools for education of their ward. Bracket mein S. Full stop. Thus, that will amount to discrimination vis-a-vis those children who are studying after paying fees. Full stop. Petitioners were always free to pay the outstanding dues, obtain TC, and seek admission in government schools or municipal schools or schools where there is a quota for RTE. Thus, petition fails and is dismissed.
Number 35.